Essays on Untouchables and Untouchability Political by Baba Sahib Ambedkar. Chapter 2 3. The Hindu inhabitants of the town saw the scene. They were taken by storm. They stood again aghast, witnessing this scene which they had never seen before. For the moment, they seemed to be stunned and paralyzed. The procession in form of fours marched past and went to the chowder tank, and the untouchables for the first time drank water. Soon the Hindus, realizing what had happened, went into a frenzy and committed all sorts of atrocities upon the untouchables who had dared to pollute the water. These atrocities will be narrated in their proper places. The assault committed by the Hindus on the untouchables at Mahad when they entered the chowder tank was undoubtedly a challenge to the untouchables. The untouchables, on the other hand, were determined not to be satisfied with merely exercising their right, but to see it established. They naturally felt they must take up on the challenge thrown at them by the Hindus. Accordingly, a second conference of the Untouchables was called. The Untouchables were told that they must come fully prepared for all eventualities for Satyagraha, that is, for civil disobedience and even for going to jail. The Hindus, when they came to know of this, appealed to the district magistrate of Kolaba for issuing an order against section 144 of the Criminal Procedure Code against the untouchables, prohibiting them from entering the chowder tank and polluting its water. The district magistrate refused and said that the tank was a public tank open to all citizens and he could not by law prevent the untouchables from taking water therefrom. He advised them to go to a court of law and get the right of exclusive use established. The date fixed for the conference was the 25th, 26th, 27th of December 1927. As these dates drew near, and as they heard that the untouchables were quite in earnest, and knowing that the district magistrate refused to come to their rescue, they did the only thing that was open to them, namely to get the right to exclude the untouchables from a public tank established by law. Accordingly, 9 Hindus drawn from different castes joined as plaintiffs in filing on 12 December 1927 a suit number 405 of 1927 as representatives of the Hindus in the court of sub-judge of Mahad. I and 4 others were made defendants as representing the untouchables. The suit was for obtaining a declaration that the said chowder tank is of the nature of private property of the untouchable classes only, and that the untouchable classes have no right to go to the tank nor take water therefrom, and also for obtaining a perpetual injunction restraining the defendants from doing any of those acts. On the same day on which the suit was filed, the plaintiffs appealed to the court for a temporary injunction against the defendants, restraining them from going to the tank and taking water therefrom, pending the decision of the suit. The judge, holding that it was a fit case, granted a temporary injunction against me and the other defendants on the 14th of December 1927. The temporary injunction issued by the judge was sent to Bombay and was served upon me 2 or 3 days before the conferences actually met. There was no time to have consultation and no time to postpone the conference either. I decided to leave the matter to the conference to decide. The conference was called with the specific object of establishing the right to take water from the tank, which was challenged by the Hindus last time. The district magistrate had left the way open, but here was a judge who had issued an order banning such action. Naturally, when the conference met, the first question it was called on to consider was whether to disobey the order of injunction issued by the court and enter the tank. The district magistrate, who had been favorable to the untouchables, now took a different view. He explained his view very clearly to the conference, which he came and addressed personally. He said that if the civil court had not issued an injunction, he would have helped the untouchables in their attempt to enter the tank as against the caste Hindus, but that as the sub-judge had issued his order, his position had become different. He could not allow the untouchables to go to the tank because such an act would amount indirectly to help them to break the order of His Majesty's court with impunity. He therefore felt bound to issue an order prohibiting the untouchables should they insist on going to the tank, notwithstanding the injunction, not because he wanted to favor the Hindus, but because he was bound to maintain the dignity of the civil court by seeing to it that its order was respected. The conference took what the collector had said into its consideration and also the reaction of the Hindus to the attempt of the untouchables going to the tank in defiance of the order of the court which they had obtained. In the end, the conference came to the conclusion that it was better and safer for them to follow law and see how far it helped them to secure their rights. It was therefore decided to suspend civil disobedience of the order of the judge till the final decision of the suit. The occasion for civil disobedience never came because the untouchables won the suit and the Hindus lost it. One of the principal reasons which led to the untouchables to follow law and suspend civil disobedience was that they wanted to have a judicial pronouncement on the issue whether the custom of untouchability can be recognized by the court of law is valid. The rule of law is that a custom to be valid must be immemorial, must be certain, and must not be opposed to morality or public policy. The untouchables view is that it is a custom which is opposed to morality and public policy, but it is no use unless it is declared to be so by a judicial tribunal. Such a decision declaring the invalidity of the custom of untouchability would be of great value to the untouchables in their fight for civil rights because it would seem illegal to import untouchability to civic matters. The victory of the untouchables in the Chowdhury Tank dispute was very great, but it was disappointing in one way that the Bombay High Court did not decide the issue whether the custom of untouchability was valid or not. They decided the case against the Hindus on the ground that they failed to prove that the custom alleged by them in respect to the tank was not immemorial. They held that the custom itself was not proved. The tank became open to the untouchables, but the untouchables cannot be said to have gained their point. The main issue was whether the custom of untouchability was a legal custom. Unfortunately, the High Court avoided to give a judgment on that issue. The untouchables had to continue their struggle. The end.